So good afternoon, everybody, and welcome to today's webinar. It's all around IR35. Are you affected? Do you use subcontractors? And if so, to ensure that you understand the risk. So I am joined today by Jag Jeer from Maven Services. So thanks for joining us today, Jag. Jag's going to be working through the risk of having self-employed subcontractors, what you can do to mitigate that risk, and also what happens if you do nothing and have nothing in place. So if I move on to the next slide, today's webinar agenda. First of all, I will do a brief introduction to Jag, give you a little bit of information about Jag and his background. Then we'll be covering off some slides to enable our attendees today to understand IR35, whilst also looking at the impacts and risk of businesses using self-employed subcontractors. We'll then follow with a member Q&A. So you should see at the bottom of your screens, you have a Q&A section. Please do feel free to pop any questions in the Q&A, and then what we will do is answer them as we go through towards the end of today's webinar. If there are any specific questions, then do feel free to contact myself directly, and I'm more than happy to arrange an introduction for you to have a chat with Jag directly. We will then be recapping the webinar takeaway. We've got a freebie that is available to members, and I'll also include the links for any of the attendees today that do wish to find out more. So again, thanks for joining me this afternoon, Jag. Just to give everybody a little bit of an overview, Jag has operated in the arena of self-employed tax risk and IR35 for over 14 years now. He's provided risk management services to the likes of Transport for London, Network Rail, Amazon, Everest, Anglian and Balfour Beatty, with an unbeaten track record of successfully defending 29 cases over the years in employment tribunals and HMRC inspections. Jag is a specialist in the field of assessing employment status and payroll. He sought to set up Maven Services in December 2019, making Maven the contractor's first choice for businesses that engage self-employed workers. So without further ado, I'd like to welcome Jag along today and look forward to the content that he'll be sharing with us. So thanks, Jag, over to you.
Thanks, Nicola. That's quite an introduction. Let's hope we live up to the billing. Okay, so to get started, two key areas that we're going to be looking at today. Firstly, when assessing the self-employed element of engaging contractors, you have to look at two key areas here. The first one we look at is something called tax law. And tax law is where HMRC will focus on the contract and engagement of individuals and classify them, whether they should be taxed for PAYE purposes, which is your pay as you earn on an employment basis, or whether they meet the requirements of being self-employed in the UK. And obviously being self-employed in the UK, the legislation has changed and moved around a fair amount, probably since about 2007, if you like, since the Finance Act. And it's quite hard for businesses to specify whether individuals actually meet the requirements today. So if businesses are unsure, they tend to take a belt and braces approach to taxation and engage individuals on an employment basis, which carry its own costs, as you know. The other area that we'll be looking at is something called employment law. Now, employment law, this is quite a hot topic because employment tribunals look at the rights of individuals and whether or not individuals who are self-employed can claim the rights of employment, but also whether or not they can claim the rights of being a worker, which has come into really the UK from the EU in the last really 5 to 6, 7 years. A number of individuals have won cases in employment tribunals, and we'll look at a case study later on in the slides.
Brilliant. So,
tax and employment status compliance. Now, a legislation that came into force in 2014 is called the Onshore-Employment Intermediaries legislation. This legislation came in because HMRC lost a case when trying to classify some duty-free workers at the airport as employees on the contract. The case was for around £4 million. It was called Talent Core, the case. I won't get into the nitty-gritty of it, but ultimately HMRC lost the case on the grounds that the individuals had the right to send a substitute. And those who are in the audience today listening and watching will know if they've got a contract for services in place, there will be a clause within that contract, which is the rights of substitution. It's common to have the clause in the contract. Whether or not the actual application of that clause in reality is actually is enforced is a whole different ball game, if you like, because the reality is a lot of the time the clause is drafted, but it never really happens in practical application. So HMRC lost the case on the grounds that there was a rights of substitution. Because they lost the case, they focus now solely on something called supervision, direction, and control. So today, businesses must either make sure that contractors that they want to pay on a self-employed basis, whether it's a limited company, CIS, or a sole trader, that they are not subject to the right of supervision, direction, or control. Also, it can't be drafted in any of the contracts in the supply chain. If you're, for example, you're a subcontractor and there is a main contractor operating above you, you have to have sight of all the contracts in the chain to make sure there's no contractual right of supervision, direction, or control. And very often it is in the contracts for insurance purposes. So ensuring that, one, the contract is right, and secondly, the reality matches the contract. That's very, very important. And obviously, if you can't prove that there's no supervision, direction, or control, businesses must pay individuals PAYE with full national insurance contribution deductions being made. What are the risks of not meeting the requirements of self-employment? So this is where it kind of gets a little bit, there's somewhat a grey area. However, to keep things very black and white, which is what we do as a business, if you can't prove that there's no supervision, direction, or control, and you still engage people on a self-employed basis, you do face potential penalties of unpaid taxes and national insurance contributions, which can go back up to 6 years if there is a HMRC status inspection. Now, if any of the audience have ever experienced one of those, they'll know how difficult it is and how time-consuming it can be, and also the financial impact it can have on a business, not to mention the time spent and the stress involved for business owners. That is something that people always say when they've been party to an experience such as that. They know how difficult it can be and how taxing it can be on the individuals involved. So what HMRC can do is force a business, if they can reclassify individuals as PAYE, they can force the business to pay back unpaid PAYE tax, national insurance contributions, which cover employers' national insurance. And if they get a claim for that, then they're likely to get a claim for holiday pay and also for backdated pension claims as well. So that's one area of risk, is HMRC looking at the business from the top down. The other area of risk, which is very, very common today, are employment tribunals. Again, if you have individuals that you're paying CIS or sole trader, you have individuals who, some might say chance it, others would say quite strategic in their approach, because there are things like the Union of Great British Workers which go around targeting sole traders, whether they be drivers or CIS individuals, and say, look, how long have you been working for this business for? And they'll say, I've been with the business for 5 years. Potentially there's a claim for unpaid holiday pay going back up to 5 years. So employment tribunals don't just look at the black and white. They look at the emotion of individuals and how they feel that they're being treated. And very often I meet businesses and they'll say to me, my guys have been with me for many years now. They don't really work for anyone else. And I would say to them, do they feel like they're part and parcel of the business? And the answer is very often yes. Individuals feel like they're treated like employees, but they get the tax breaks of being paid on a CIS or sole trader basis or through their limited company. So that's the area of risk in terms of employment tribunals. And the other area is worker rights claims. So if anyone listening doesn't understand what a worker classification actually is, it's something that sits alongside employment. It's further away from them being self-employed, but a worker has rights to things such as backdated holiday pay, pensions, rights to unfair dismissal. And worker rights claims, they can go back, and holiday pay claims can now go back as far as when the individual started with the business. So years ago, there was a 2-year stopgap on holiday pay claims. That's now changed because of a case a few years ago in the home improvement industry, sash window workshop, where an individual won a claim. He was a self-employed salesman, was working for a business for 12 years, paid commission only on a self-employed contract. He won the rights of a worker through the European Court of Justice, and the judge awarded the claim for holiday pay 12 years back to when he first started. And bearing in mind, he had actually retired. So again, businesses think that they have a good relationship with their workforce and they'll never make a claim against them. But now individuals can make a claim within a year of when they finish working for the business. So the relationship is finished, it's severed. There's no income now from the relationship, but they can backdate a claim. So those are really the areas of risk that fall when engaging self-employed individuals. So this is something that the reason for covering this off today is because we've seen a number of inspections and claims being won where companies who engage a workforce, whether it be through an intermediary or through a payroll company or through a recruitment agency where labor is being supplied, they are not carrying out something called supply chain checks, the assessment. So due diligence on the supply chain. The reason why this is an issue now is because HMRC, under the new IR35 guidelines, which will come into force in the private sector this April, can actually look at any party in the supply chain and potentially make a claim for unpaid tax and national insurance contributions if necessary checks have not been carried out. So it's very, very important now for businesses, if they are involved in the supply chain of labour, to check that the businesses are carrying out the right vetting processes, legitimacy of taxation, and that there's an assessment carried out at least once a year. Failure to do that means that you could be liable for a claim if someone else in your supply chain isn't carrying out the necessary checks. So it might sound like all like doom and gloom. However, this is something which is probably about 18 months old now, and we know HMRC are enforcing supply chain checks. It's really important to carry out some due diligence on other parties in your supply chain. The risks of not doing it, obviously unpaid tax, national insurance contributions, transfer of third-party debt in supply chain, not to mention things like reputational damage. Generally, businesses that we work with have been trading for a period of time, and their business name and reputation precedes them. And I know it's that's part of the kind of philosophy within CH4B as well. So businesses should not just look at themselves here, just also look across the supply chain. We can help obviously with the assessments and the right sort of checklist you should carry out, because you may be unable to actually recover things like VAT payments. And worse still, there is criminal prosecution for facilitating things like tax evasion, not to mention modern day slavery. We know exploitation of workers is something that there's a moral responsibility for all employers to make sure that they are adhering to, and social responsibility as well to the labour that they're engaging. So whilst you want to take people on a self-employed basis and they're contractors, there's still a social and moral obligation for carrying out the necessary checks as well. So if you're unsure about that, again, ask the right questions, because you don't want to fall foul of this. If there is an inspection, if you're engaging a limited company, the IR35 rules come into force, which we'll cover off shortly. And the IR35 rules have been around for many years now. They came into force in the public sector. There was a reform which took place in the public sector back in 2016, which would have affected supply chains, including the likes of Balfour's and Transport for London and Network Rail, etc. But it's now come into force in the private sector earlier this year. So if you are unsure, we're happy to help with that as well. Right, so this is actually a very good case actually for us to cover off. I've chosen a case study here where The background on this is you have a company called XL Brickworks, a contractor operating within construction, the CIS scheme, and you have a foreman and a bricklayer who have been part of the business supplying services on a self-employed basis, taxed CIS, so 20% deducted. One individual was there for a year and another there for 17 years. So they're both operating on a self-employed contract. So the client thinks that they're putting the right measures in place here to guarantee kind of self-employment and mitigate this employment status challenge that there might be. The individuals have choice over how they provide their services and the work. And also they have the rights of substitution drafted into the contract, which, as we said earlier, is very common to have in contract for services, whether they've been drafted now or 5 years ago. You know, the individuals were never paid things like sick pay or holiday pay, so those employment rights were never covered off. And they also took on other work that included private work and work for other entities as well. The judge in this case, this was last year, awarded a verdict that these individuals were actually employees of the business. So how did the judge arrive at that decision? This is something that's very important here. Is one thing, you can have a contract in place, but if the reality of the day-to-day services that the individuals are providing is different to what's in the contract, and there is an element of control in place over how they provide their services, they're potentially employees or workers at the very least. The judge argued that the individuals were integral to the operation, seen as, certainly someone who's been there for 17 years, seen as a real key element or cog of the business. And there was no evidence of any checks being made and audits being made, whether or not these individuals were supervised, directed, or controlled. One of the key elements here of what you have to do is make sure that you are assessing, and it should really be done on a job-by-job basis, that the individuals are not supervised, directed, or controlled. And that's really about the manner of which how the individuals provide their services, that they're not being shown how to do their job. But you have to evidence it. That's the important bit, and that's what businesses fail to do. And the judge finally settled that the individuals had an employee-employer relationship. So really, it felt like there was a master-servant relationship here, which really forms the basis of a contract of employment. As we know, there's no definition of self-employment, if you like, in the UK. However, there is a very key definition of what someone looks like when they are employed on a PAYE basis. And so this is a very good case because it sets out the scene as to many things that actually the company thinks that they're doing very well. The reality is something very different. So the company now faces backdated employers' NI on those earnings of those two individuals, potentially going back up to six years for one, and certainly 1 year for the other, unpaid taxes, not to mention opening a can of worms on the rest of the workforce. And that is quite dangerous for a business. And, if you look at earnings on kind of based on £600-700 a week, it's £4,000 to £5,000 per individual per year. Yeah. And if you've got 30 bricklayers or individuals working for you, you're into hundreds of thousands of pounds in backdated penalties that could be owed. Yes, they're going to appeal the case, and we'll look out for the verdicts on the appeal. However, first case has been won by HMRC. So this is very, very important that companies get the reality right compared to what's happening in the contract. Because anyone can put a contract in place. Proving the definition of the contract is something very, very different.
Yeah, no, definitely.
So moving back onto IR35, as we know, it came into force in April this year, the private sector reform, bringing it in line with the public sector back in 2016. For those who don't know what IR35 is used to describe really two sets of tax legislation, and it's designed to combat something which is known as disguised employees in the industry, individuals who are taxed on a self-employed basis and take earnings at national minimum wage and the rest in dividends, so they get all the tax breaks. The reality is they're employees of the business, or they're treated like employees of the business, or the reality is they are employees of the business. So it's seen as avoidance of taxation, which HMRC take a very dim view of. And the crackdown into the private sector was forcing individuals to, one, look at the contract and how they're operating, and two, make sure the reality matches the contract. So this was brought into the private sector in April this year. There are some businesses which have been made exempt from it. An exemption has been applied to really small businesses. So if we move on to the next slide, there's some key criteria here. And if two of the criteria don't apply, you're exempt. So the key thing here is if you are a business and the annual turnover of the business is 10.2 million or above, or the balance sheet total of more than 5.1 million, or you have over 50 employees, only two of the criteria need to apply and the legislation applies, and therefore you have to act and make sure you're adhering to the new set of legislation. And that brings into a number of elements which are on the next page actually. So to bring you up to speed with what you have to do to make sure you're complying with this legislation. Firstly, you have to make an assessment on the personal service company, the limited company that you're paying. If you are paying the limited company, you're classed as the fee payer, and the fee payer is now liable for, one, making the assessment that the limited company meets the requirements, for being taxed outside of IR35, which means they can take payments into the limited company on a self-employed basis, or they are operating inside of IR35, which means they are supervised, directed, or controlled, don't have the rights of substitution. There's an obligation on them to provide the services on a personal basis, but also as an employee. And in doing so, they must take income on a PAYE basis to the limited company. So the first thing you have to do is make an assessment. There is a CEST tool, which is the employment status tool on the HMRC website, which you can use. My only advice is, if you choose to use the CEST tool on the HMRC website, is that it will not be used should there be a challenge by HMRC. The reason being is they have challenged it recently in a case. They've challenged a decision against their own tool, actually, which doesn't really help the situation, because everyone thought we could use the tool actually to evidence that someone has passed the test and they fall outside of IR35. So you need to carry out a very fair assessment. It should be carried out prior to the works beginning, and the limited company should also have the rights to appeal against the case. So in making the determination, you have to issue something called a status determination statement. It is basis of how you've arrived at your decision, whether you class them inside of or outside of IR35, and giving reasons for the determination. If they want to appeal, they have 30 days to make an appeal, and it should be a fair process. The other important point here to give reason to is you cannot make a blanket assessment. So you can't make a broad brush assessment based on 10 people doing a similar job if they're all limited companies. You have to assess each limited company on its own merits, and each limited company should be given the status determination statement. Failure to give the status determination statement could mean penalties. This is where we come back to supply chain due diligence and making sure that you are assessing and carrying out what's important to you as a business to make sure that you comply with the legislation. Because if you don't carry out the determination and issue that statement, the liability can move up the chain, it can move down the chain to any party. So HMRC's powers now have been kind of spread a bit further wide now, so that they can go to any entity in the supply chain, and if you haven't carried out your due diligence, you could potentially be liable. So very, very important, as the fee payer, you meet your responsibilities.
Brilliant.
Thank you. So how to deal with all of these elements of risk? Maven Support Services, very briefly, we on behalf of CH4B, we would carry out a free risk assessment, which allows us to look at the engagement and the relationship that you have with your workforce. We have a number of checks that we carry out. They go from contract to reality as to how the services are provided across a wide range of sectors. We have an audit process which tackles the reality test, and it's something that we carry out in the background every 3 months, certainly for higher risk areas. It's important that you protect yourself against HMRC investigations. There's a lot of debt which the Chancellor will look to claw back from, certainly from the self-employed sector, whether they are sole traders or in the CIS or within the limited companies. So the limited companies, there's also something else you should be aware of, which is called the Tax Anti-Avoidance Rule Team. If you are paying limited companies directly and you sought to move them out from limited company arrangement into like a sole trader arrangement, there is something called the Tax Anti-Avoidance Rule Team, which would look at that mass exodus and it would red flag an investigation straight away. We advise strongly against anything like that. For us, the best form of defense is compliance. We deal with the legislation as it's drafted, as it's written, as it's intended. We comply, and we form a very strong defense based on our layered approach and application of processes. So for us, it's about tackling changes with legislation. Subcontractors can access a range of benefits. Obviously, by coming through CH4B, you have discounted service fees. And if you are unsure about your contracts or your supply chain, we're happy to help.
Right. Thanks for that, Jag. I know there's quite a lot of information there, and I know from sort of conversations that we've had previously with other members that there is going to be a target around self-employed individuals from the revenue, especially when we look at the debt that's been created via coronavirus and some of the they want to challenge. Can I be right in saying that some of the inspectors can actually go onto sites now and start to speak to the self-employed individuals operating on the sites?
Yes, they can. And what we've seen now is inspectors have formed an alliance with the Home Office, HSE inspectors, and that's all in line with HMRC and things like the CIS return. So this is in line with immigration. So we've seen inspectors going onto site and actually targeting the individual, the actual operatives, the contractors, as opposed to going to the client. And in doing so, they'll ask the contractors a number of questions, and contractors don't know the answers. They'll just say, "Yeah, I work for this company. I've only ever worked for him or her, and I invoice the business." They'll say to them, "Oh, are you like employed by the business?" And they'll say, "No, yeah, I feel like I'm employed." Or they'll say, "Are you supervised?" "Yes, I'm supervised. We've got a supervisor there. There's a supervisor." And it's just so obvious. Yeah. Before you even get into HMRC status inspection, they've already collected the ammunition, if you like, and you're already on the back foot. So clients who work with us, if they do receive a letter from HMRC, they forward it straight on to me. Our legal team will pick it up and we deal with the communication with HMRC. It's really, really important that first communication is a line of defense, and we deal with the letter and the periods and what HMRC are actually requesting for to the letter. So we keep it very much boxed in within the realms of what HMRC are looking for. And that could be a status inspection. It could be a special investigations unit, an SI investigation, which actually is very, very aggressive. It can be from HMRC. So yes, absolutely. They are going to site. Unions are even helping this situation because they're lobbying for more employment rights for individuals. But yeah, they are working with HSE officers and with the Home Office now. So it's a lot easier for them to just gain access and ask questions.
Okay, so I've had a question come in, Jag, just on the Q&A as we've been going through. The question reads, is the liability on the business, or is there any liability on the individual? If so, is it different if they are self-employed or as an individual limited company?
Okay, so based on the IR35 reform, if we look at just a limited company arrangement, first of all, whoever is paying the limited company is now liable. It used to be that the limited company was liable for the correct taxation and how they took their income through the limited company. That's changed now. So if you're a contracting business and you're paying a limited company directly, you are the fee payer, you are responsible, you are liable for any penalties for 1, not issuing the status determination statement, 2, getting it wrong, or 3, not following the compliance rules in the first place. So if you're paying a limited company, you are liable, not the limited company. If you're a contracting business and you're paying people self-employed and they're being paid as a sole trader or through the CIS scheme, for example, you are responsible and liable for unpaid taxes if they are reclassified as either PAYE or as workers. So again, it's the business entity that is liable. There is something which is called transfer of third-party debt and supply chain. And if there has been fraudulent evidence or documentation produced, there is personal liability for business owners, and that includes personal assets as well. So it's quite hard hitting. That's actually been enforced for around 3 years now, and we have seen cases where business owners have become personally liable as well. So really important for business owners, peace of mind. Either deal with the legislation, which we can help with, or bring Maven into the supply chain. Let us take on the risk. We'll absorb it. We sit between the client and the individuals, absorbing the employment status challenge. The client is no longer at risk. The business owners are no longer at risk, and it's Maven that's at risk. And we're very comfortable at forming a very strong defence.
Okay. Brilliant. Thanks, Jags. I've had another question come in, and it's something that I've spoken to you on many occasions. So what is the difference between a payroll company, or like just an umbrella, if you like, compared to the service that you offer?
It's a good question, actually. It's something that, payroll subcontractors like Maven, for example, are very different to an umbrella company. So an umbrella company works with generally recruitment companies, and they process an invoice and take a margin. There's no employment status risk management process in place. They're simply paying individuals, and it's more of a payment service that an umbrella company provides. Because the party that is liable is the recruitment company. Under the Onshore-Employment Intermediaries legislation, whoever is deemed to be intermediary one is liable for the tax risk. So umbrella companies don't take on any tax risk. It is the recruitment company that is still liable. Even if the umbrella company is paying people on a self-employed basis, it is intermediary one, the recruitment company, that is liable. The difference actually is if you're a payroll subcontractor, Maven is a payroll subcontractor, we take on the risk. We engage with the individuals. We have a contract for service with the client. We become responsible for the tax challenge and absorbing the employment status challenge should there be one. So we have to have the contract in place. We have to have an audit process in place. The correct taxation and end of year tax obligations are met by individuals. So there's a huge difference between one charging a fee for just processing an invoice, which is really like a bureau service. And that's what an umbrella company really provides, or a payroll subcontractor like Maven, where we're actually responsible and taking on the risk. So we can't just work with anyone. We have to assess the risk. We have to make sure we're comfortable taking on the risk. We have to implement some changes with businesses to make sure the reality matches the contract. And then we test it on an ongoing basis to make sure the audit stands up as genuine evidence. Because if HMRC do come to us and they feel like they've got a case against us, we have to evidence that we are meeting the requirements of the legislation.
Perfect. Okay. So I know just from speaking with a couple of members that we've got, some members think that they already have things in place because they don't do the payroll, for example. So it's definitely worth reviewing what is in place, because it comes down to that that status, doesn't it, with regards to who is liable and where they fit. So no, that's great. Thank you for clarifying that, Jag. The other thing that I was going to ask, because I know I get asked it quite a lot speaking to various business owners, is around sort of CIS payments and the payroll, and obviously how that solution works. Am I right in thinking that you take over sort of the CIS for the clients?
Yes, so clients, let's say a client pays 20 CIS individuals on a Friday morning. What will happen is, if we're engaging in the supply chain, we'll deal with the risk element, contracts, audit, register the subcontractors with Maven, subcontract their services to the client. The tax risk sits with us. Client will send us a schedule for the payments to those contractors on a weekly basis. We'll raise an invoice plus VAT to the client. They'll send us the payment over for services, inclusive of margin, and then we will pay the subcontractors less the CIS tax. We will be responsible for doing the CIS returns for the individuals by the 19th of each month. The client will still submit one CIS return to HMRC. It'll be a gross payment entry, so a nil entry, which means that they are meeting their CIS requirements. But in doing so, the client also benefits from saving on the CITB levy. And that's a fairly important point, because very often clients feel like they are part of the CITB but don't get any actual benefit. It's just a levied tax, which they have to pay every year, 1.25% on all labour-only payments. So it can be quite a substantial amount every year that they have to pay. By the individuals going on our CIS return, we become liable for the levy, not the client. They can still access the grant scheme as well, which means that they can get something back from the levy for the first time without having to be paying the actual tax. So the clients can still utilise the grant system, but they save on it as well. But yeah, we process the payments on a designated day time the client wishes for them to be paid. So there's no change to the payment to the subcontractors. It's just a payment process through Maven.
Okay, I've had another question coming, Jag. This typically happens once one question's been answered, they seem to fly through. So apologies if I'm firing so many things at you.
No, that's good.
One of the questions that have come in is around supply chain. So you mentioned, obviously, and I know from experience you've worked with the likes of Network Rail, National Rail. It comes down to the supply chain. So with a lot of contractors now, the mains contractor are kind of actually saying in those contracts that they can't work with self-employed subcontractors, etc. I know that you've got experience with satisfying sort of Network Rail and National Rail on those points to ensure that they can still operate in line with the legislation. Would you mind just sort of giving us a bit of an overview for that, just for the member that's asked the question? Because sometimes the responsibility is higher up the chain and they make the decision, so it's how you can mitigate that, especially if a member has obviously looked at the contracts they've got in place, they've reviewed the contracts with their mains contractor, and they've taken the steps to employ individuals. That's quite costly for that business. Obviously, with furlough coming to an end in October as well, that's going to have a knock-on effect. So in terms of if there was an opportunity to U-turn that, whether it would be in the business's best interest to do that, and how they can satisfy the mains contractor.
Of course. So what we've done in the past with actually Transport for London and Network Rail is actually invite an audience and have a meeting with them. It starts with the contract in the upper tier, and it's about satisfying what they call the spirit of the contract and making sure that the actual risk of employment status, one, doesn't go up the chain, and in that scenario, you have to have the correct business model and audit process that Network Rail and Transport for London and the likes of Amazon feel comfortable that actually down the chain, individuals can be paid on a CIS or sole trader basis. There's no risk of the tax liability going up the chain to them. And if you can satisfy them on the business model and audit process and contract you have, you've certainly got an opportunity to engage them on a self-employed basis, as we've done in the past. And it is about engaging with the company, with the main contractor, and showing them how you go about mitigating risk. If all you're doing is providing the payroll service, then of course there's potential transfer of third-party liability. For an umbrella company, there's absolute risk as well. But if you are genuinely removing, mitigating and managing risk, because the risk doesn't go away, it has to be managed. And it has to sit with the entity that's saying we're engaging it, we're absorbing it, and we're comfortable with that risk. If you can satisfy all parties in the supply chain, certainly up the chain, then there's certainly an acceptance of self-employment further down the chain. So we've done it in the past, and it's certainly something that we can look at again. As I say, we do it for the likes of Amazon now, where there's potential concern of risk going back up to Amazon, where you have self-employed drivers being paid. There's 25,000 in around the M25 dropping parcels off every day, paid on a sole trader basis, gross payment, no tax deducted. At least in the CIS scheme, there is 20% deducted, and there's a UTR, there's a verification there's more of a chance of someone submitting a tax return at the end of the year. So it can be achieved. The main thing is to get an audience, and our understanding of TfL, Balfour's and Network Rail is that things aren't necessarily about financial penalty. It's about reputation. It's about operating within the spirit of the contract, and they would allow for it if you can meet the requirements. And it's not about providing an indemnity, because an indemnity really isn't worth the paper that it's written on or typed on in a court of law. It's about the process of application. That's the key thing that they will look at. If you have someone who's potentially open to the idea of self-employment and they understand the legislation, you know, the one thing I remember very clearly from Transport for London was we were the first company to actually invite a meeting with them and satisfy their requirements, which is why we had 200 people come through on a self-employed basis. And it was quite rare for them to actually have an audience with a company that operated in my industry, because most companies they're not comfortable, if you like, with that level of risk.
Yeah.
There isn't that level of risk if it's managed.
Okay. I've had a knock-on question that's come through, Jags, just on that, that reads, how have companies like Network Rail and London Underground managed and mitigated the associated risk?
So back in 2016, when the IR35 reform came into force in the public sector, there was a huge change of job roles, and everyone was classed as inside of IR35. And what those businesses did, they made a broad brush assessment of individuals, which was that they're all inside of IR35. So come April the 5th, 2016, all these individuals went from being paid on a CIS basis. Let's say they were working on the tracks, they were welders, etc., and they all of a sudden had to go PAYE.
Right.
There was a huge uproar at the start of April from the workers. So within 2 weeks, Network Rail and Transport for London changed the assessment, and they moved them all back to being CIS because they were about to lose the workforce.
Right.
Really, it was the power of the individuals that took over in that scenario, because as we know, a lot of self-employed people, even regardless of how much they earn, they're hand to mouth, week to week. They don't save, they don't plan for pension generally, and you know, their earnings were hugely affected from being 20% tax to being 30-40% tax, plus the class 1 national insurance contribution. So back then they took one stance, and then because of the uproar, they went 360 degrees the other way.
Yeah.
So now, I mean, since then, there's been quite a huge changeover where we've seen far more companies become comfortable with self-employment, and generally that self-employment acceptance has come around, might be from working with a company like myself, whereby which you bring in or you outsource the expertise of compliance for self-employment, because it generally isn't companies' strong arm, if you like. So outsource it, bring in the right expertise, bring in the right partners to the business, which is where a business like ourselves can come into it, where companies don't necessarily have to pay for the service. Some do, some don't. The margin we deduct can come from the individuals, but it's a lot cheaper than putting them on an employment basis, where the costs are 26%, 27% plus pension, not to mention the ongoing fees of, like you said, with furlough coming to an end and having to continuously employ people. Having a flexible workforce, and we don't say everyone should be self-employed in a business, because you won't pass the elephant test with HMRC. There should be limited companies, there should be PAYE, there should be apprentices, and then you can have a flexible workforce within that regime as well. So our goal is to make sure companies comply, but keep the margins in the right place as well. So we're very commercial from that perspective. So allow businesses to maximize profitability at the same time.
No, fantastic. Thanks, Jags. I'm just checking. I haven't had any more questions come in. I know we're nearing the end now. So what I wanted to do is just recap the key takeaways from today's session. So the first one is the importance of reviewing that workforce. Do they satisfy that self-employment status, etc.? What risks and what mitigation can you put in place. The next one, obviously the impact of IR35 and the risk of using subcontractors, things like you say, going back 6 years, that's setting a catalyst for the rest of the workforce. If somebody was successful with holiday pay, sick pay, how expensive and detrimental that could be for any business. The fact that actually businesses can remove the cost, remove the risk with no cost or very little cost, depending on the agreement that they have with the individuals. I know that that's definitely something that's quite commercial with regards to how we operate and support business owners within the community. I think most importantly is actually having a 360 view on the whole supply chain, because actually it's really important to consider what everybody within that supply chain's doing, because it can go up and down, can't it? So as much as it can go up the chain, it can go down the chain and go back up, if you like. So I think that that's definitely key. I think the main takeaway for any attendee on today's webinar, any of our members, is if you are unsure, just book that free risk assessment, because ultimately you might have been in a situation where you've been forced down a road to make individuals PAYE, thinking that that was the only option. But actually there are things that you can do to mitigate that, especially with furlough coming to an end. And the other way, if there are businesses that are signing up to contracts, they're unsure on the rest of the chain, even if you do your bit within that chain to remove that risk, it no longer sits with you. So I think that that's probably one of the most key takeaways, just to find out, ask the questions, have that initial call. So in terms of the member freebie, if you just want to cover that off, Jags, I know we've touched on it with regards to sort of the risk assessment, the consultation, but if you just want to introduce that just to the attendees.
Yes, of course. So for us, we're happy to provide a no obligation free risk assessment to any of the CH4B community. And it is about looking at the engagement between the clients and their workforce. That includes contract review and also the day-to-day reality audit process of how the individuals are providing their services, with a proposal and recommendations for change. And then clients can decide, basically have an informed view of their workforce relationships. And it does change over the years. I think self-employed individuals have become very comfortable and part of the fabric of many of these businesses. You've got to separate it. You've got to deal with that risk. If you don't, it is a ticking time bomb. And you may choose to do nothing about it. And at some point, you may have a larger problem than you should have had, or you can mitigate it now.
No, thanks for that, Jag. So if any of our attendees today do want to find out more, please feel free to visit the website and register your interest. Alternatively, you can contact me directly on the contact details on screen. I can then facilitate the diaries and look to schedule an initial consultation in with Jags, even if it's to have a conversation initially. So thanks once again for offering that to all of our members.
Pleasure.
That brings us to the conclusion. So thank you everybody today for attending. As always, there is a feedback form at the end of today's session. We are very much member led, so we do really appreciate your feedback on today's webinar. If you do have any questions and you didn't feel comfortable to present them in the Q&A section, please do feel free to get in touch with myself, and I would be more than happy to arrange an introduction. So thanks again. Thanks for your time again, Jags. Really appreciate that. Thanks to all the attendees today. And I look forward to touching base with you all individually. Thanks very much.
Thank you.